Welcome back to Canadian Justice, where we're discussing a strange piece of legislation called the National Security and Intelligence Committee of Parliamentarians Act, the NSICOP Act. This is a piece of legislation that led to leader of the opposition, Pierre Poilievre, declining to get security clearance because he viewed this legislation as putting him in a catch-22. It silenced his ability to speak about certain issues even in Parliament. And Ryan, you really have a problem with this law. You brought a legal challenge to Section 12 of the NSICOP Act, the provisions dealing with that potential 14-year term of imprisonment for parliamentarians who speak about certain issues, even in Parliament. You challenged that law, and you did it as a self represented litigant. Now, I've got to say, you are not a typical self rep. You are a law professor. Can you explain why you felt so strongly about this law that you wanted to go and challenge it yourself?
Well, it was somewhat shocking to testify to a Senate committee and to say there's serious issues involving the constitutionality of the act, and essentially to have that brushed off. Insofar as I'm saying, well, this is so significant that it actually requires the amendment of the Constitution of Canada, if in fact you want to do this. What they effectively thought was, well, no, even if we're implicitly amending the Constitution of Canada without admitting that we're doing this, it's all fine because this is very significant and really important. As somebody who cares a lot about constitutionality and the rule of law, I just really couldn't take that lying down.
And what was your experience like as a self-represented litigant? I mean, most law professors, they are generally not duking it out in the courtroom. They are not typically doing that. So what was that experience like?
I would say extremely humbling. If you think that just because you understand the law or you can teach it, well, they say those that can't do teach. But I would also say very encouraging on the other side, because what I saw was that all the lawyers who've been involved in this, including the lawyers for the Attorney General of Canada, took this very seriously. And I think that they were very patient and they operated without any sharp practice, kind of recognizing the importance of the issue. So it kind of restored my faith in the ability of addressing these sorts of issues in the Canadian courts.
And I mean, you did incredibly well. It's obviously going to the Supreme Court now, and you actually won at the lower court level. The lower court found that this law was indeed unconstitutional. Paul-Erik, why don't you jump in here and tell us what the lower court found about the legality of the NSICOP Act in Ryan's challenge?
Yeah, sure. When Ryan said it was a humbling experience, I suppose that must be right in some sense, but he did a pretty darn good job because, at first instance, he successfully persuaded a judge of the Ontario Superior Court that Section 12 was unconstitutional and invalid. And the court said Section 12 of the Act infringes on that constitutionally protected parliamentary privilege of free speech and debate by allowing for that kind of prosecution, and that you can't impose this kind of legislation without the constitutional amendment, very much accepting the argument that Ryan had put forward. So it was, you're exactly right, Christine. It's unusual that self represented litigants get to this point. Ryan has done a bang up job advancing a very important case quite successfully.
So, Ryan, is there anything you want to add to that description of the decision of the lower court? Anything that stood out to you from their decision? Um, eh, or maybe even what it was like when you received the decision that you, as a self rep, had actually won this case?
Well, it was exhilarating. And you think, well, people understand that it's really important that we be completely explicit about the amendment to the Constitution. The backup argument, so the argument in the alternative the Attorney General had made was that, well, we could do this pursuant to Section 44, which would mean that we wouldn't need to involve the provinces. And that's really quite disturbing because the idea there would have been, well, we amended the Constitution. We didn't admit we were amending the Constitution, but we could have done that anyway. So really, it's no big deal. And that argument was squarely rejected.
Yeah, that's a discomforting argument to be made by the Attorney General for sure. Now, you were successful at the lower court level, but the Court of Appeal of Ontario reversed this decision on appeal. We've got to go to commercial break now, but when we come back, I want to get into what were the grounds of the appeal and what the Court of Appeal decided, maybe why they decided it, because I mean, it was a significant victory for you. Uh, Overturned, but now it will be heading to the Supreme Court for a final resolution. So when we come back from commercial break, we're going to dig into what the Court of Appeal found and maybe why the Supreme Court is so interested in hearing this case. We'll be right back.